Good morning, members. I know many of us haven't seen each other since yesterday, but if you would make the first priority today, sign in to your microphone, and we'll get this show on the road. Thank you. We warmed up. We got 3, 5, 7, 9, 12. I know, but I don't want to call us to order if we don't have a quorum. Here we go. Yeah, we're going. Good morning, everyone. Good morning, and for our members up here, please sign in so that we can soon take the roll. For those of you out there, I'm Kevin Vaughn. I'm the chairman of the highest rated internet committee show on the World Wide Web. So if you like what you see today, we'll take a 5-star rating and 2 thumbs up. Helps get our message out there across all platforms more. And if you can find a place to do that, you're more internet savvy than I am. Okay, if everybody's logged in, Madam Clerk, would you take our roll or set us up? Everybody in? That's a little iffy. We're all right, hit your blue button. Representative Lynn, hit your blue button, the PNV. All right, it looks like we're all in our places with bright, shiny faces. What's our number?
Mr. Chairman, you have 18 members present. You have a quorum.
All righty, thank you. Folks, we've got a jam-packed calendar today. The snow day caught us off guard last week. I hope everybody enjoyed that. We also have a presentation today. We've got some housekeeping to do as we go through this. So we're going to work today and take care of the people's business judiciously. Again, my name is Kevin Vaughn. I am your benevolent dictator of this committee room. I want all to find what they seek here. And we're going to start by adjusting our calendar. House Bill 1096 by Speaker Sexton is going to be rolled to the heel of this calendar. We'll let other folks come in and come out. So that puts us on House Joint Resolution by Leader Cochran.
Thank you, Mr. Chairman. If you'll stand by one moment, I would like to present the appointment of David Jones to the Public Utility Commission.
We've got a motion and a second on that. Is Mr. Jones with us? Or hello, Mr. Jones. Welcome back. For those of you, hopefully you've been provided with his bio. He is a standing member on Tennessee Public Utility Commissioner. He comes out of, I believe, the natural gas pipeline world. Is that not correct? All right. Does anybody have any questions of the applicant, or do we want to move on? If we have any questions for you, we'll ask you to come to the table and give your name. But like I said, you've been serving in that role for the past term, and we appreciate your service. And we do know that you're a pretty sharp engineer, and we appreciate you serving the public in that manner. If there's no objections, we are going to take care of this House Joint Resolution to reappoint David Jones as a Public Utility Commissioner. All those in favor, let's signify by saying green on your screen. So, Madam Clerk, can you Can you set us up for voting? Let's go green. Please take the roll. Take the vote.
Mr. Chairman, you have 19 ayes.
And I didn't see any nays there, so congratulations on your reappointment, Commissioner Jones. We appreciate your service. All right, what we'll do since Leader Cochran is here with us, I hope you don't mind if we roll you to the right in front of me.
Perfect.
To the next to the heel.
Perfect. Thank you, Mr. Chairman.
All right. You're also rolled to the heel on 110. Next is House Bill 182 being presented by Chairman Grills. Chairman Grills, are you here? I saw you briefly. We're going to roll Chairman Grills 2 spaces. We are knocking them out. Delayed gratification is gratification anyway. All right. Representative Garrett, House Bill 817. We got a motion and a second. Sir, you're in proper posture. Please share with us this year's riveting trust amendment.
Thank you, Mr. Chairman and committee. I do have an amendment that rewrites the bill. That coding ends in 3684.
Got a motion and a second. All those in favor of attaching amendment to House Bill 817, please signify by saying aye. Aye. All right, the amendment's attached. You're good to go.
Thank you, Mr. Chairman and committee. As the chairman indicated, this is my 7th time to update the trust legislation as it relates to trust laws in the state of Tennessee. And just in case some new members of the committee, this is my wheelhouse and my law practice. I do estate planning and lots of trusts. Over the past few years, we have more than tripled the amount of trust dollars that are in the state of Tennessee for legislation just like this. We've gone from $25 billion over the past 9 years to, believe it or not, almost $300 billion, Mr. Chairman, under trust monies that are inside the state of Tennessee. That doesn't necessarily the people are here, but they're certain their money is here. And why is that? It's because legislation just like this and what we've done in the past several years to make this a state where we want to make sure that any trust here has the best regulations. It's a highly regulated industry, and we make it as easy to administer those as cheaply as possible, et cetera. That's why folks want to bring their pieces of legislation, their trust money here. So what this does is really sort of a cleanup bill, definitional bills. It describes who can serve as a public trustee in variances where a trust may not name a particular successor trustee. It also defines how you can access certain disclosures by electronic means. Everything's going to an electronic way these days. We need to keep our codes updated to make sure certain notices are satisfied in the electronic world. It also clarify who can receive actual notice on behalf of a beneficiary, et cetera, of a trust, if they are representing the trust in any manner as a trustee, a trust advisor, et cetera. It also provides certain costs that can be reimbursed to certain trustees and also to certain settlers. For instance, if there is a mechanism they may be personally responsible for a particular tax, this can be attributed to the trust and reimburse that person if they pay any type of tax that might be owed under the earnings of the trust. And it also clarifies who can act as a non-beneficiary and serve in a non-fiduciary capacity under a trust, like an advisor to a trust, if that's appropriate. So with that, Mr. Chairman, I'll be happy to go any further in those particular details, but that's a brief overview of the certain sections that are updated for this particular trust legislation. So with that, I ask for your support.
Question on the bill.
Thank you for that. Thank you for that riveting, as very thorough, as I might add, explanation. I saw Representative Hardaway's hand up down there.
Well, and thank you, Mr. Chairman. And I appreciate your expertise in this, sponsor. When there is the genesis of this is the Bar Association come together and do stuff and then suggest it for the state, or just how do we start doing all these modifications or amendments of the statute?
Great question, Representative Hardaway.
Thank you.
Mr. Sponsor.
Likewise, Mr. Chairman, that's an excellent question, and I failed to let you know where this bill originated from. This comes from the Tennessee Bankers Association. They have a committee made up of trust and estate lawyers that come up with these type of things that they see in their practice that they run into. There's a problem here with the definition, or there's a problem there with a beneficiary, and then they come to a committee, present those particular problems through the Bankers Association, and then they bring that to me. I've attended some of those committees to make sure that I understand the problem, so I have somewhat of a background of what some of the issues are. So this legislation has been brought to me as the past 6 times that I have presented this legislation from the Bankers Association from their Trust and Estate Lawyer Committee.
Thank you, Chairman. I only remember 5 of those.
That's impressive.
All right. Thank you, Chairman. Thank you, sponsor.
Thank you very much. Does anybody else have any questions of our bill sponsor for this year's edition? If seeing none, we will, Madam Clerk, would you prepare the board for us to vote on this matter? We are now taking the vote. Tally the vote, please.
Mr. Chairman, you have 21 ayes, 0 noes.
Thank you very much. Let's see, Representative Garrett, you will be moving on to calendar and rules. My bad. Calendar and rules. Thank you, sir.
Thank you, Mr. Chairman Committee.
Hang in there. We are going to take care of House Bill 908 since you're at the podium right now. We've got a motion and a second. You're in proper posture. Share with us what you're doing here, Representative Garrett.
Thank you, Mr. Chairman. House Bill 908 opens up a market which we currently do not have in Tennessee for subordinate loans. Those are loans that are HELOC loans. If you want to take out a home equity line of credit right now, and it's beyond 15 years. Right now, we're using the current 30-year Treasury yield. All this piece of legislation is doing is changing it to the current market for if you want to get a home equity line of credit beyond 15 years. So if you want to do a 20-year home equity line of credit in your home right now, you've got to use a rate that there's no companies that provide that rate because the margins are too thin. This is allowing companies to do home equity lines of credit here in Tennessee that are more than 15 years. So with that, Mr. Chairman, I'd be glad to take any questions that the committee may have to clarify any.
Thank you. I see Chairman Boyd over here. Chairman Boyd, you're recognized.
Thank you, Mr. Chairman. And sponsor, I think it's a good bill. They came to talk to me about it, but when I was talking to the stakeholders that came in, they used the term line of credit rather than loan. And I heard you say that as well. Line of credits usually have a variable rate because they never know when you're going to tap into it. I think you're talking about home equity loans here, right? Not a HELOC, but a HE loan. Is that correct? Just for the record.
Bill sponsor.
Thank you for that clarification. That's right. Thank you for that clarification, Chairman Boyd.
All righty. Chairman Boyd, you're taken care of. I saw Representative Hardaway's hand.
Thank you, Chairman. And the first question, of course, is this something that the bankers or the mortgage lenders bring from their meetings or? And I'll go ahead and get a second one so you can flow into it. Are there safeguards in place to prevent predatory lending?
Mr. Sponsor.
Thank you, Mr. Chairman, and thank you for that question. Yes, this was brought to me by the lending industry because this currently can't exist right now. Now, you can get a loan in this space for up to 15 years, but it's if you want something beyond that, we're using the current 30-year Treasury yield, and it's just going to the market using the 30-year average prime rate, offer rate, which is what's being used currently for loans up to 15 years. And to kind of piggyback on your second question, this does not even implicate a situation where these are predatory loans whatsoever. The same applicable laws would apply to the current ability to get a loan for 15 years or less. Same laws apply if it's 15 years or longer for this type of loan. This doesn't open up any door to a potential issue as it relates to a predatory loan that's already out there currently.
All right. Thank you, sponsor. Thank you, Chairman.
Thank you. So let's give this a recap now so that we all understand what we're doing. The benchmark rate that we were using has gone out of vogue because it was 30-year, and so these loans are not being made because it was tied to an antiquated benchmark. Now we've added a new benchmark that suddenly makes these instruments more attractive to be offered to the marketplace. Is that a succinct statement of it?
Yes, Mr. Chairman.
All right, thank you. Not seeing any other questions. Oh, I do see one down here. Deputy Speaker Zachary.
Thank you, Mr. Chairman. Representative, is there a cap? Does this legislation have to do with raising the interest rate and raising the cap, or am I thinking of another piece of legislation?
Bill sponsor.
I think you might be referring to another piece of legislation. I'm not aware of a cap, but this does not have a cap.
Deputy Speaker.
Thank you, Mr. Chairman. So this is not where they're charging a 30% interest rate and bumping this up to 36.
Bill sponsor.
That's right.
Just wanted to clarify. Thank you.
Chairman Lafferty.
Thank you, Mr. Chairman. And I was just curious, are these loans going to be secured like a primary mortgage would be through the federal government, or are these still held? Will the banks that write these loans be responsible for these loans if they fail?
Representative Garrett.
These loans will be secured by, usually by the borrower's home. It's going to be a second mortgage that's subordinate to their primary mortgage. So all the collateral sense would be vested in whatever assets are put up for collateral.
Thank you. Thank you, Chairman.
All right. Y'all, my firecracker was about to go off in my hand there for a minute. I was about to call the vote a little bit early. If everybody's satisfied, let's vote it now. Madam Clerk, could you prepare the board? Please tally the vote.
Mr. Chairman, you have 22 ayes, 0 noes.
All righty, super. You are on to calendar and rules.
Thank you, Mr. Chairman, committee.
We're going to go back now. We're going to revisit House Bill. House Bill 32? 180, House Bill 182 by Chair Lady Littleton. Madam, you are recognized. Thank you. Now you're in proper posture. Let's talk about the curiosity about what Bill 182 was going to do was eating me up. So I want to hear about it.
All right, thank you, Mr. Chairman. Y'all scared me for a minute there. I didn't do my homework and ask for a motion or a second. House Bill 182 enacts the Ink of Hope Act, which requires each tattoo operator or tattoo artist, before receiving a permit to operate a tattoo establishment or to apply a tattoo, to complete an up to 1 hour online in-person training at no cost to the applicant by a nonprofit organization approved by the Tennessee Human Trafficking Advisory Council that focuses on how to recognize the signs of human trafficking and how to respond to those signs, and how to refer a client to the resources for victims of human trafficking and reporting signs of human trafficking to the Human Trafficking Resource Center hotline.
All righty. Thank you very much for your work in this field. We do appreciate it. Do we have any questions for Chair Lady Littleton? Well, we have Representative Hardaway is very inquisitive today. He's got a questions for Chair Lady Littleton.
Thank you, Mr. Chairman, and thank you for this, Chair Lady, because this will also, you correct me if I'm wrong, this will also help to address some of those situations where the sex traffickers actually tattoo their victims so they can keep up with them.
Chair Lady?
That is true. That's the purpose of the bill, because they do that. And so Thistle Farms brought me this bill. And so a lot of those ladies that work there, and men too, have been tattooed and marked.
Thank you, Chairman. I thought it was important that we put that on the record. Thank you, Chair Lady.
Thank you, and thank you for bringing this, Chair Lady Littleton. Anything we can do to impede that scourge from our boundaries, our borders is greatly appreciated. With that, if I see nobody else needing to contribute here, we are going to vote on House Bill 182 and send it on to calendar and rules. Would the clerks please prepare the board? Everybody's already participating. That's a great sign to see. Does everybody cast their vote? Does anybody want to change their vote? All right. Please count it up for us.
Mr. Chairman, you have 22 ayes, 0 noes.
All righty. Thank you. Chair Lady Littleton, you're on your way to calendar and rules.
Thank you, Mr. Chairman and committee.
All right. We're back on track now with House Bill. Which, House Bill 459? House Bill 459, we've had a request to roll it for 2 weeks. House Bill 343. Motion and a second. Mr. Bill Sponsor, it's good to see you this morning.
Good morning, Your Benevolence and Committee. Thank you for entertaining me this morning.
It is always, let me just state this for the record. It is always a pleasure to be in the company of another member of the Cutie Patootie Caucus.
Yes, sir. Absolutely.
Shout out to Betsy Phillips.
We are an elite group, Chairman. We are.
We're certainly a peculiar group. All right, let's, and all of those who are curious about that, check out the Nashville scene. You'll get a good chuckle. We do have all the members here with us today. I was feeling a certain brotherhood in the room.
Yeah. Yeah.
All right, Representative Capley.
Can feel the love, Chairman. Thank you. Chairman Committee, this bill is obviously imperative to national security. We are seeking to place protections against Chinese and other counterfeit lighters. They are dangerous. We are prohibiting in this piece of legislation the sale of lighters that do not comply with the American Society of Testing and Materials. This bill is supported by the Lighter Manufacturers Association, all major lighter manufacturers, BIC, Zippo, you name it. We are not seeking to change anything regarding the novelty lighter law, and we do have exemptions placed in code for those that are transporting lighters and those that are storing them for distribution, and that is what the bill does.
Thank you, sir. So to get this right, we're trying to keep folks' faces from getting burnt up by a lighter that blows up.
That is correct, Your Benevolence. Yes, sir.
All right. Any questions for our bill sponsor? All right, Chairman Faison.
Thank you, Mr. Chair, Mr. Sponsor, Chairman of the Cutie Patootie Club.
Caucus.
Caucus, yeah, thank you. Do you, I'm interested, the lobbyists came to see me yesterday. Do you have an example of what a bad lighter is? I just make sure I don't buy one if we don't get this law passed.
Mr. Sponsor.
Mr. Chairman, I would assume a bad lighter would be one that doesn't work. I wasn't being the cutie patootie when I said that either.
I do appreciate a succinct explanation. Thank you, Chairman Faison.
So not just ones that don't work, but our benevolent dictator chairman said one that would blow your face off. So I'm interested in one that actually does work and intends. Do we know a brand of one or what they look like or anything?
Well, first, let me say, Chairman Faison, we're not here endorsing lighter products, but I think that all right, so here's one of the things that I looked at, because when I first saw this bill, I was concerned about the kind of spoke to protectionism, and I'm kind of a free market guy. But what it speaks to is the fact that the American Society of Testing Materials is almost like they're a clearinghouse to make sure that products, or they're a group of manufacturers that have specifications by which products are manufactured. Obviously, the lighter industry has a recorded standard practice for the materials and means and methods of manufacturing of convenience lighters. What we see is the imports coming over do not have that ASTM certification. And that is what this bill is doing, is saying that if our retailers are going to be selling lighters, they meet the ASTM standard. And so that was what got what kind of told me this is a valid thing to do as a consumer protection measure. Anybody else?
That's the lighter version of it.
That was good.
Well done.
As far as brands go, Mr. Chairman, I haven't brushed up on my Mandarin ever, so I wouldn't be able to tell you.
Understood. Understood. Does that satisfy everybody's curiosity? Are we ready to vote? Representative Hardaway, I'm sorry, I did not see you.
Thank you, Chairman. And if it's blowing up folks and blowing up their faces, I'm curious, what type of exemptions would you have for that? Thought I heard you
Mr.
mention
Bill Sponsor.
exemptions earlier.
The exemptions are for the transportation and the distribution, those that are already in place. So we don't want anybody that, has a warehouse or that's transporting them right now. If it becomes into law, we don't want them to get charges just going forward.
Gotcha.
Yep.
Thank you. Very wise.
Thank you. Everybody cool? Excuse me. Is everyone are you ready to cast your votes? I think we're ready to vote. If we could, clerks, please prepare the board for voting. Has everyone cast their vote? Anybody want to change their vote? If not, let's close it out. And Madam Clerk, tell us the score.
Mr. Chairman, you have 23 ayes, 0 noes.
All righty. Thank you, ma'am.
Thank
Sponsor,
you.
thank you. And you're
Thank you,
off the
Chairman.
calendar and rules.
Thank you.
Where are we now? Who's the sponsor? House Bill 683, I don't see Leader Lamberth in, so we are going to roll his bill 1 week. 1 week on House Bill 683. Where are we going now? Hello, Representative Parkinson. Hello, sir. It's good to see you today. Please tell us you're in proper posture with a motion and a second. Please let us know what you're doing here.
Thank you, Mr. Chair, and thank you, committee. This bill instructs TASER to study the economic impact of the cosmetology and barbering industry in our state.
All right, we had a very thorough discussion about how much we love our hairdressers last week. No need to go back into that because I may say something inappropriate at home that gets me in trouble when I get back. So I'm going to keep it zipped on that matter. But do we have any other questions for Representative Parkinson? Not seeing any. Oh, Representative Lynn.
Mr. Chairman, is this the annual cosmetology bill or will there be more coming?
For those of you who aren't aware, is that it's interesting that how people that serve in the legislature, since we are citizen legislators, have certain knowledge bases that we tend to bring bills in that field, and people get used to seeing certain people carry certain bills on certain subjects. And Representative Parkinson is our resident cosmetology expert. That industry owes him a great debt of service. So that was what Representative Lynn was addressing. And you know what? Every time he brings one, I learn something. So I hope not. All right. Not seeing any other questions. Would the clerks prepare the board for voting, please? Madam Clerk, could you tally the vote for us?
Mr. Chairman, you have 22 ayes, 0 noes, and 1 present not voting.
All righty. Thank you very much. This is going to calendar rules. You're off to calendar and rules.
Thank you, Mr. Chair, and thank you so much, committee.
Representative Jones, we'd like to welcome you to the Commerce Committee, presenting your first bill.
Thank you, Chairman. This is HB 499.
Well,
It's a-
hold.
Oh, sorry.
Representative Jones? There was a very important piece to the puzzle that you might have been missing there for a moment, but now you're in proper posture. Please share with us what your bill intends to do.
Thank you. Sorry about that. It's HB 499. It's a cleanup bill from the Secretary of State's office. When a registered agent resigns, Tennessee law requires the registered agent to file official resignation papers with the Secretary of State's office. And the registered agent must send a copy of the official papers to the business that it represents. This copy has to be sent by certified mail. There has been some confusion by some businesses as to why a copy of the notice was sent to them. And there's been confusion by some of the agents about whether the copy of the official resignation papers must have the Secretary of State stamp showing that the papers were filed. which cannot happen since the registered agent has to send the copy before it files the official papers. So this bill just simplifies the statutory language to say that the registered agent must provide the business written notice of its resignation by certified mail as opposed to the actual Secretary of State form. This change will allow the registered agent to send a simpler, clearer message to businesses and will benefit both the registered agents and the business.
That sounds like a wonderful thing to do. Let's stop all this confusion out there. Does anybody have any questions for our first time bill presenter in the Commerce? Representative Hardaway.
Thank you, Mr. Chairman. Good morning, ma'am.
Good morning.
How are you?
I'm good. How are you?
Good. I appreciate your explanation, but I'm not quite sure, is the resigning agent officially resigned at the time of the submission of the resignation papers to the comptroller, to the Secretary of State, or is the resigning agent officially resigned only after the Secretary of State has responded to the official notice of the resignation?
So both have to happen.
Excuse me,
Oh, sorry.
Mr. Bill Sponsor, you're recognized.
Thank you. I cannot get used to that. Yes, sir. So actually, both have to happen before he is actually officially, or her is actually officially resigned.
Representative Hardaway.
Thank you, sir. So I'm having a problem in reconciling if the resigning agent is not officially resigned at the time of the submission of the resignation, but instead the resigning agent is only officially resigned after the submission of the resignation and having received the official response from the Secretary of State. Isn't that counter? Isn't there a lot of contradictions in that?
You know, Representative Hardaway, I'm resigned to myself to hearing more questions. So, Bill Sponsor, would you do your best with that one?
Yes, sir. Actually, we have the Secretary of State office here if you would like for him to explain that.
Trust me, they don't want
Excuse you know what? Madam Sponsor, I don't think he would be nearly as informative as you are. We think we'll just stick with you. Anyway, thank you for bringing this bill, and thank you for being good natured about a little ribbing every now and then. Seeing no other questions, we've got a question is about to be the vote is about to be taken. So could you load us up, Madam Clerk or Mr. Clerk? Cast your votes. Anybody want to change their vote? Let's end the voting and tally them, please.
Mr. Chairman, you have 22 ayes, 0 noes.
Thank you very much. You are on to calendar and rules.
Thank you, Chairman and Committee.
Thank you. Chairman Howell, it's good to see you this morning. Appreciate your patience with us. We've got a motion and second. We appreciate you explaining House Bill 100 to us.
Thank you, Mr. Chairman. Members, it's always good to be with you. A few months ago, the Cleveland City Council changed the utility company that they own to a Cleveland Utility Authority. It came about when they expanded to provide broadband as well as electricity, water, and wastewater. During the transition, there was an unfortunate error. They need a better lawyer. And they left out Section 2, which allows the board to be compensated for their due diligence and duties that they perform. So I'm urging you to pass this bill so that I can remain in good standing with the members of that board, so they can be compensated.
All right. We don't want anyone thinking ill of Chairman Howell, so we need to get this cleaned up. Any questions for Chairman Howell? Seeing none, would the clerks prepare the board for vote? Cast your vote. Does anybody want to change their vote? If not, Madam Clerk, could you tell us what the score is?
Mr. Chairman, you have 23 ayes, 0 noes.
Oh, that sounds like a win to me. We're going to get you back in good standing, Chairman Howell. You're off to calendar and rules.
Thank you, Chairman, members.
It is time, the time that all of us have been eagerly awaiting, and that is the Chairman Boyd portion of the calendar. Chairman Boyd, you're recognized on House Bill 1136.
Thank you, Mr. Chairman, committee members. House Bill 1136 clarifies that broadband, although at the federal level, it has been shifted around a couple of times from Title I to Title II, which is information services is Title I, Title II is telecommunication. And as that continues to bounce around, it'll probably move again. We want to clarify that in the state of Tennessee, regardless of where it's at, that TPUC does not regulate that it is regulated at the federal level under the FCC. And it also removes a mandate that TPUC had been filing a report for probably over a decade now. That's not necessary anymore. And that's what the bill does, Mr. Chairman.
All righty, thank you, sir. And from my understanding, it's not necessarily something that TPUC is not willing to regulate. They're just don't have the capabilities now, and we'd have to stand up more departmental resources, which would basically be a duplication of what the FCC does already. And so we need some clarification on that. Do we have an amendment on this, Chairman Boyd? I'll give you a hint. Yes, we do.
We do have an amendment, Mr. Chairman. Yeah.
Motion is the House Bill Amendment Drafting Code 3552.
That's it, Mr. Chairman.
Let's get, although motion second on adding the agenda. Anybody got any questions about the agenda? All in favor, please signify by saying aye. Aye. Any opposed, no. Ayes have it. The amendment is now attached. No questions on the bill as amended. Seeing none. Would the clerks please prepare the board for a vote? Hey. Thank you. Anybody want to change their vote? If not, would the clerks tally the votes, please?
Mr. Chairman, you have 22 ayes, 0 noes.
All right, sir, you are on to calendar and rules. $10.97. Oh, that was 11:36. Let me clarify. That was 11:36 as opposed to 11:38. 11:36 is on to calendar and rules. Now we're going to talk about 11:38. I was getting ahead of myself.
Motion.
We've got a motion and second. Chairman Boyd, let's hear about that one.
Yeah, Mr. Chairman, committee, this is a pretty simple bill. When blasting is done, there's a pre-blasting survey that's completed. Current statute allows that a homeowner can request that, and it has to be given to them, but we never clarified what the price was. And so this just clarifies that they can get one for free. I had a homeowner that they were doing some blasting in the neighborhood, and he needed to get a copy of it, and they were going to charge him $150 for it. And so it just says that you're entitled to one at no cost.
Any questions on this bill? Seeing none, let's vote on this bill. Would the clerks prepare the board, please? Open up for voting. Everyone cast your vote. Anybody want to change their vote? Representative? Everybody's okay. Would the clerks tally the votes for us?
Mr. Chairman, you have 22 ayes, 0 noes.
Thank you, ma'am. Chairman Boyd, you're off to calendar and rules with your blasting bill. We're going to go back and recapture some of the items that we rolled so that we could get folks who were not members of the committee taken care of. So we're going to go first to House Bill 128 by Leader Cochran. Sir, you're recognized.
I can address it real quick. Thank you, Mr. Chairman. And so as this is an admin bill and Chairman Boyd is our House expert on all things workers' compensation, he has been so gracious as to carry this bill through the process. And so if it's okay, I would like to yield to Chairman Boyd.
Thank you for that. Thank you for that, Leader Cochran. Again, much as Representative Parkinson is all things cosmetology, Representative Garrett is all things trust, in comes Mr. Workman's Compensation. Chairman Boyd, please tell us what we're doing this year with our workman's comp.
Thank you, Mr.
I
Chairman,
apologize.
committee. This is a bill from the Bureau of Workers' Comp. It just makes a few changes. It extends the Next Step program, which gives scholarships to injured workers. It extends the sunset for attorney's fees. It raises the criteria for becoming a workers' comp judge, and it allows them to serve one additional term longer than they have previously. I'll take any questions, Mr. Chairman.
Thank you. Do we have any questions of Chairman Boyd? Seeing Representative Hardaway.
Well, I'm curious as to why that would be necessary.
Chairman Boyd.
Which portion are you alluding to?
Representative Hardaway.
All of it.
Chairman Boyd.
All right. Here, I'm happy to indulge. Mr. Chairman, the Next Step program has been very beneficial, provides up to $5,000 per year, up to 4 years for injured workers. We think that's a pretty good program. We would like to remove the sunset on that to allow those injured workers to get an education to get back into the workforce. There's a program by which if a worker is injured and the actions or the insurance company or the employer were egregious, then attorney's fees can be awarded. That is something that we have protected and just moved along with various sunsets. We're just extending that sunset period 5 more years to June 30th of 2030. The other thing is the workers' comp judges, when the reform took place years ago and they created the workers' compensation judge program, it was really the first time it'd been done, but the judges that are doing this are very knowledgeable. This is all they handle was workers' comp cases. And so we want to keep them there. So instead of them being able to serve 3 terms, we want them to be able to work a 4th term and continue to preside over these cases. And because more people are wanting to become workers' comp judges now, we're raising the minimum age from 30 to 35 and your experience level from 5 to 7 years. So we're just kind of tightening it up. Mr. Chairman.
Thank you, Chairman Boyd. Has that got you squared away, Representative Hardaway?
Yes and no, sir. I don't know why we would increase the age limit and wipe out the expertise that was cited as a requirement, even though it's merely a 5-year difference. It's still possible that individuals would have that expertise. That's part of what I was hoping to hear in the explanation. And the other part I didn't hear you speak to is whether or not, how the difference in current law and this bill speaks to notice of the injury and whether an employee would be able to recoup their claim amount if they're late with the notice, as opposed to being able to recoup the full claim amount if they've been on time. I don't see, the way I'm reading it, that's a penalty that wipes out any claim to that period between when the injury may have occurred and when the employer gets actual knowledge/notice. I don't see why that's fair. Maybe you can help me with that.
Chairman Boyd.
Which section are you talking about here? I'd like to look and see what you're talking about.
Well, I'll tell you what, Mr. Chairman, I'll get with them offline.
All righty.
I'm looking at notice of injury.
Okay. Anyone else have any other questions of the bill sponsor? Chairman Clemens.
Thank you, Mr. Chairman. And I'm curious, I haven't heard from the Bar Association on this. Is the Bar Association, where are they on this? Have you heard from them?
Chairman Boyd.
I did not consult with the Bar Association on this.
Chairman Clemens.
Thank you, Mr. Chairman.
Any further questions of the sponsor? All righty. We're going to open up the board for voting at this time. Please cast your votes. Madam Clerk, please tally the votes.
Mr. Chairman, you have 18 ayes, 4 noes.
All right, thank you very much. That bill passes, and you are off to calendar and rules. Chairman Boyd? We're going to go back. One of the things that, again, it's Rusty getting back in the saddle. I failed to note that the appointment of Mr. Jones to the Public Utility Commission is being referred to calendar and rules. I'll do better next time, I promise. That brings us to 410, 110. That brings us to House Bill 110. Who's got it? Oh, Chairman Bricken. I got caught up in cleaning up some mess there and forgot that you were carrying House Bill 110.
Motion.
Oh, sir, you're recognized. You're in proper posture.
Thank you, Mr. Chairman and members of this committee. This bill comes to us from our friends over at the Department of Financial Institutions. It really just simply authorizes the commissioner of the Department of Financial Institutions to determine the type, the amounts, and other characteristics of deposit insurance for our state banks that they must maintain. And that's what the bill does.
Thank you, sir. Chairman Clemens, you have a question?
Yeah, thank you, Mr. Chairman. I'm curious, if he doesn't have this authorization now, who makes that determination at this time?
Chairman Brickens.
Thank you, Mr. Chairman. Our statutes are just silent about deposit insurance today. And this bill clarifies, because we don't know what's going on necessarily on at the federal level on the possible consolidation of all the federal banking regulators. And the commission just wanted to get ahead of it and be assured that he would have the authority that all our state banks maintain the proper amount of deposit insurance for our citizens. So that's the reason for this legislation.
Chairman Clemens.
Thank you, Mr. Chairman. Well, I appreciate that. If that's the aim of this legislation, to ensure that that insurance remains in place rather than what is being proposed at the federal level, I think it's a good thing. I would hope that he, if that is his true intent, to make sure that that deposit insurance is required at an appropriate level, then I appreciate the legislation.
Thank you, sir. Seeing no other questions, let's take a vote on this. Would the clerks load the board for us? Thank you. Everyone cast your vote. Anybody want to change their vote? If not, the clerks tally the vote, please.
Mr. Chairman, you have 21 ayes, 0 noes.
All right. Bill passes and is on its way to calendar and rules. No, I got to do mine. Now we go to the heel of the calendar, which is I'm presenting House Bill 1096 on behalf of Speaker Sexton. So I will pass the gavel down to our capable Vice Chairman Bricken.
All right. I am not prepared. What bill number are we talking about?
1096, Chairman Bricken.
All right. Thank you. All right.
The best one on the calendar.
Motion. All right. We have a motion and a second in proper posture of House Bill 1096 by our leader, Chairman Vaughn. Would you like to explain the bill?
Yes, sir. This bill is, the prime sponsor of this bill is our Speaker, Sexton. I'm presenting this on his behalf, and it's dealing with a situation that we're beginning to see more in Tennessee, and it's one that we have some concerns about. And for those of you who are not experienced in this level or have not come across these, community benefit agreements are agreements that communities require new businesses to enter into prior. Okay. Okay. Community benefit agreements are benefits that are supplemental to awards that ECD may make to a company to have them relocate here. These agreements can require companies to provide prevailing wage. They can specify that they use union labor. They can specify that they provide different amenities for certain people inside their community. And that is something that I feel needs to be addressed, because whenever the ECD, or State Department, vets a company and has someone ready for relocation, and the company accepts the award and are ready to relocate, well, they need to already know what's going on with regards to what their award is. I know that when in land use business, I was always told that, because one of my first times out, I went in and told somebody, said, hey, and I thought it was a great idea that, you know what, if you'll rezone this corner for me, I'll donate you a fire station site. And the city administrator said, oh, no, you don't buy zoning here. You don't quit. We know quid pro quo land use decisions. And so what's happening in this is that companies think that they're getting ready to relocate, and now they've got to enter into this agreement with this community or the local jurisdiction, and then whatever special interest groups that they deem necessary, and they get to load the wagon against the company one more time. And what's the consideration for that? The consideration is, oh, we will allow you to do what you should be able to do by right anyway. And so what we're saying is that if you receive ECD benefits, then you are not allowed to enter into a community benefit agreement. And we believe that this will protect companies wanting to relocate to the state, if that's understood. To get this, I think I've got an amendment though, Vice Chairman.
And that amendment number is?
3718 is the last four digits.
Do we have a motion second on the amendment? But, all right, any objections to putting the amendment on the bill? Hearing none, all say aye.
Aye.
The amendment is now on the bill. Now, is that makes the bill?
It makes the bill, and that concludes my remarks. I'll be glad to stand for questions. I know that my good friend from Davidson County and I tend to disagree on this subject matter, so I'm sure he's got some points he'd like to make, and I welcome those.
Representative Clements, you're recognized.
Thank you, Mr. Chairman. And again, just to reiterate my concerns from the subcommittee, Mr. Chairman, we do agree on the part about you being a free market kind of guy. And I tend to agree with you in that respect. And so we like to keep our hands off of businesses unless absolutely necessary to protect the public, protect the community interest and consumers and employees. And so we generally, this committee in the past has not overstepped into telling corporations what they can and cannot do beyond that. And that's just good public policy, in my opinion. And here we are using state economic benefits as a hammer to tell corporations what they can't do. And in this case, we're telling them that they can't do things that benefit the community, that benefit employees, that benefit consumers, that benefit and protect the interest and goodwill of the community into which they're entering. And so I think this is in direct contrast to all notions of a free market and hands-off kind of a policy that we have proudly followed in this state, in this committee. So, again, I stated these concerns last week. Community benefits agreements require the agreement of two parties. One is the corporation and one is the community. They both enter into those. Some of them, corporations enter into them voluntarily to provide adult professional training, community rooms for arts activities, internships for local schools, affordable housing initiatives, and grant programs to benefit the community. Those are the types of things that are contained within community benefits agreements. And so here we are saying, Corporation X, if you want to do good, if you want to be a member of the community and voluntarily enter into an agreement with the community and say what you're going to do, then you're not getting any state money. That makes no sense to me. It absolutely is adverse to all notions of good public policy. So, again, I stated this last week, so I obviously oppose the legislation, Mr. Chairman, and I know it's not yours, but thank you for letting me get that on the record.
Chairman, you're recognized for a response.
Yes, one of the great things about where we live is we are free to disagree. And so having someone having a disagreeing position from me doesn't hurt my feelings. My friend is still my friend. But what I see in this vehicle that's out there is agreements have to be fair, two-sided agreements. So what does the company get from this community benefit agreement? Well, the unstated part is if you do this as a company, then we'll allow you to do what you should have rights to do anyway. We're going to add things to you. We're going to make you, we're raising the bar on something beyond where you should be. And so my concern is that the unspoken portion of these agreements is if you don't give us everything we want, we're not going to let you relocate here. Even though the land use may be approved and the state has provided benefits. And that's where I think the core disagreement come from in this. And I do respect your opinion and your ability to disagree on this.
Thank you, Mr. Chairman. A response, Representative Clemens?
Yeah, thank you, Mr. Chairman. Thank you, Mr. Chairman. I appreciate that. And I think what we're missing here is that sometimes these agreements are entered into voluntarily, and they always require two parties' agreement. That's the nature of the word. And so they're agreeing to this, and they're not always held and rarely are held captive or told they can't do their business or can't relocate somewhere unless they do this. These are sometimes and most times voluntary. And so if they voluntarily want to enter into one of these, I think a good example is the Tennessee Titans. They put out a community benefits proposal, and it was not required, but it does a lot of great things. So now we're telling them they can't benefit from any of this state, and they drive a lot of the economy in this region. So I just think we're kind of taking a shotgun approach to something here, or a hammer when we could be using a scalpel if the stated intent is what it is. Thank you.
Thank you. Any further response, Chairman?
No, sir.
Thank you. Excuse me. We'll move on to Representative Hardaway.
Thank you, Mr. Chairman. And it's pretty simple for me. I've expressed it before in sub that the values and the principles of local citizens need to be expressed, should be expressed, whether it's through their local government or whether it's through the direct agreements with those who seek to come into their community and claim to be good corporate citizens. And I'll also comment that these same corporations working through ECD are working off of the local citizens' tax dollars, and they may or may not have had input on the state level. This affords them to have that opportunity to have some say-so on the agreements through ECD, where their tax dollars or the incentives secondary effect on their tax obligations is the matter of the day. So thank you, Mr. Chairman. Thank you, sponsor. No response necessary.
No response necessary. I'll take that as a move on. Representative Hemmer.
Thank you, Mr. Chairman. Just wanted to speak to the members regarding my experience, both as a former employee of ECD, having negotiated these incentives, but also as a member of a board here in Nashville who negotiated a community benefits agreement, and why I don't think this is good policy. So I think it's important to remind members, and any ECD incentive, the corporation is agreeing to a certain threshold of job investment requirements in order to get that incentive. So they're voluntarily agreeing to that as part of that incentive today. Secondly, part of the community benefits agreement, while it wasn't fun while we were doing negotiation, like a lot of negotiations aren't very fun, having the hindsight of looking at it, it was part of the Nashville Fair Board when we recruited and had allowed the Nashville Soccer Club to put their stadium on the fairgrounds property here in Nashville. It's amounted to a lot of great things for that property and for our community. We negotiated a daycare, we negotiated workforce housing, green space. It allowed us to have a park, a number of apartments, a number of great office buildings, as well as, tons of jobs and set wages and job skill programs for youth. And so it had a number of just really, really good benefits that I think are getting lost in this discussion when these entities come to the table and voluntarily, all they're doing is just papering the things with the community and with the governments that they want to do. And I think that is very free market. I think that is a very good policy. And I think this will put a chill into that effect.
Thank you for that question. Any response, Chairman?
No, sir.
No response? Great. We'll move on to Leader Cochran.
Thank you, Mr. Chairman. And Chairman Vaughn, just wanted to thank you for carrying the legislation. Just wanted to make the point that that companies are also voluntarily, they are entering agreements with the state of Tennessee for economic incentives that, I mean, when looking at all industries across the state that have entered into these agreements to the tune of billions of dollars in taxpayer funds. And so essentially all this legislation is saying is that you can't enter into yet another agreement that somehow would impose obligations or conditions on the employer regarding employment practices, benefits, or operations that are not directly related to the performance of the employer's duties under the economic development incentive. Because the people of Tennessee have made an enormous investment in this company coming to our state. That company has guaranteed to provide a certain amount of jobs, a certain amount of economic output, and so they shouldn't be entering into other agreements that could somehow harm the investment of the taxpayers of Tennessee. You don't have to enter the first agreement, but when you do, you are accepting that financial incentive. You're accepting the incentive from the taxpayers of Tennessee with some conditions. And I don't think that's unreasonable and to protect the investment of the taxpayers of the people of Tennessee. So thank you for bringing it. I'm in full support. Just wanted to lend that word of support. Thank you.
Thank you. Any response, Chairman?
Nope.
No response. Last we have is Leader Camper.
Thank you, Mr. Chairman. Mr. Chairman, I was concerned about companies that are already here, that are already in their agreements, and some of them are in the middle of negotiating agreements. Would this bill affect any of that, or would this be like going forward? Can you, for the record, discuss how, businesses that are already here that have these agreements, how they will be affected? And if they're in the middle of negotiating at this point, how would they be affected?
Thank you. Chairman Vaughn.
Leader Camper.
Sir.
Thank you, sir. The amendment that we put on stated that this has an effective date of July 1st, 2025. So anything that's happening until that point is not affected by this legislation.
Thank you, Mr. Chairman. Thank you for that answer. So if I'm in a negotiation right now, but I haven't signed the ink on it, I still would be allowed, even if it's after July 1, if the negotiations was already ongoing, we still be able to continue those negotiations even if July 1 come, if I'm already in the process and we maybe have 2 more items to agree on or something like that? Or would it have to be signed before July 1 for it to be effective?
Chairman Vaughn, you'd like to clarify that?
Yes, sir. Leader Camper, I would encourage them to be diligent in their negotiations and conclude those by June 30th.
Thank you.
Leader Camper,
Thank you,
all right.
Thank you, Mr. Chairman. Thank you, Chairman Vaughn, for your response. That's all I have, Mr. Chairman.
Thank you. I have no other body listed for a question, so are we ready to vote?
Question on the bill.
All right. Clerk, if you'll get the board ready to vote. Everyone cast your vote. Has everyone voted? Mr. Clerk, would you close the vote and give us the totals?
Mr. Chairman, you have 17 ayes, 5 noes.
All right, having passed this committee, House Bill 1096, I don't see a fiscal note, so I assume it moves on to calendar and rules. There you go.
With amendment.
Thanks for that tidy work, Vice Chairman Bricken. That concludes our calendar for today. I believe Alex, have we disposed of everything we need to? All right, we've done that. Hold on just a second down there. Folks, let me get up here and pontificate for a moment before I recognize you. I do find the sound of my amplified voice very intoxicating, so I like to speak on the microphones as much as possible. What I want to do here momentarily, I'm going to go into a brief recess after I recognize my two friends down front. One thing that I'm concerned about is, and you'll see that through a bunch of the legislation I present to this committee and others, is the impact, the regulatory impact and regulatory inflation that affects the cost of providing primarily housing in this state. And so I've got a series of bills that I'm going to be dealing with. Some touch on taking some of the governor's third-party bills and from last year and expanding on those. I don't think the sky has fallen on any of our local communities as a result of that. And I just kind of want to make sure that we have, we're not wasting people's money. And folks, I'm concerned about the generation, my children's generation, the generation younger than them of is home ownership outside of their reach, given the economic climate in today's market. So I have requested a group to come in and speak to us today, make a presentation on the regulatory impacts on costs. They're the Pacific Legal Foundation. They're a think tank out of Washington. They've argued successfully cases in front of the Supreme Court, and we're going to be asking them to give us a presentation, but they're also appearing in front of other committees around the building today. So before we adjourn, I'd like to take a 5-minute recess once I hear from Leader Camper and Representative Hardaway and give them a time to get to the room, and then we'll hear from them, and then we'll call it a day. If people have time, I think it'll be a really important perspective from someone who's watching these issues from a national level. Leader Camper, did you need some? Do you need to be recognized?
Thank you, Mr. Chairman. I did. I just wanted to make welcome. Oh, he just left. Mr. Kermit Moore, who is the president of the Memphis branch in NAACP. I wanted to make him feel welcome. So let's clap for him anyway.
There we go. Well, I was going to say, let's let him hear it outside. Let's all rise up. Representative Hardaway.
Thank you, Chairman. Here's double embarrassment. I'm taking the mic again to recognize Mr. Kermit Moore, but in his role, he's of international note, and his role is A. Philip Randolph president. He's a long time and well-respected advocate for civil rights, human rights, economics, education, health, housing, environmental justice, civil justice, criminal justice. He's been in this fight for a long time. And I'm happy to make that recognition and ask you to give him a little applause so he can hear it outside.
All right. Thank you for that. Seeing no one else, is Mr. Miller, are you here? Oh, great. We don't have to give them time to get here. Mr. Miller is here. We are going to ask you to come down to the front. Sir? No, we're not going to take the break. I wasn't aware that you had made it here. Whenever you wear cheaters, sometimes it makes the words look big and clear and the back of the room look fuzzy. So I decided that I didn't see you back there, but we will go out of session, but we would ask for you to tell us your name, who you're with, and then share your thoughts with us on some of these regulatory issues. But we're now out of session.
Thank you, Mr. Chair. My name is Mark Miller. 12 years of affiliation with Pacific Legal Foundation, which is who I'm here on behalf of today. Before I get to my remarks, I'll just say, as a former governor's chief of staff and as somebody who for Pacific Legal testifies in a number of legislative committees across the country, I will commend you on both the efficiency and the good humor with which you run your committee. But back to my comments. Pacific Legal Foundation is the nation's leading nonprofit law firm dedicated to individual liberty and property rights. We represent property and business owners at no charge in disputes with the government. And in the 50-plus years since we opened our doors, we have won 18 out of 20 cases at the U.S. Supreme Court of the United States, as you alluded to earlier, Mr. Chair. Most of those cases are defending private property rights. Some of us at Pacific Legal Foundation do policy work, others do litigation. I get to do a little of both, concentrating almost always on property rights. I also took a 3-year sabbatical from PLF to work in state government on behalf of South Dakota Governor Kristi Noem's, to work on behalf of the Governor Noem as her Chief of Staff, General Counsel, and unborn child advocate. I helped her implement her COVID policies and then more generally cut red tape and get government out of people's hair. Those 3 years at her side were insightful for me as it allowed me time to work with state legislators like you all in this committee, taught me how the legislative branch operates and how important it is in our system of Republican government. My topic today, as you said, is housing affordability issues and regulatory overreach. As I said earlier, I work in property rights. Today, some of the most sympathetic property rights cases that Pacific Legal litigates involve residential housing. Prohibitive land use regulation is the primary cause of the housing affordability shortage, and it is a problem recognized across the political spectrum. The problem dates back almost a century. In 1926, the Supreme Court upheld the power of local governments to regulate land use through zoning in Village of Euclid versus Ambler Realty. Widely recognized at the time as destructive of traditional property rights and freedom in land use, zoning laws had their defenders, and later, as they gained broader acceptance on the grounds, the defender said that they were necessary for the quiet enjoyment of property. Insofar as that was true, it operated to the benefit of the health, safety, and welfare of communities. But the law, of course, has pushed far past those simple zoning codes of the 1920s. It has led to a frequently Byzantine command and control system of planning, which has at various times been an engine of illicit discrimination and economic protectionism that works to the advantage of existing property owners at the expense of the young and community newcomers, the next generation, Mr. Chair, as you alluded to. I want to emphasize the phrase command and control system. Here in the United States, we have understood that it's freedom and liberty that makes us great. Freedom from government control. Yet in the land use context, we forget that. We have entire categories of government employees who are called land use planners. Why do I need government planners to tell me what to do with my property? It was Ronald Reagan who said, the basis of conservatism is a desire for less government interference or less centralized authority, more individual freedom. But that's not what we have when it comes to land use. It is a system that is entirely about a centralized authority telling us what we can and can't do with our property. Very quickly, and I'm trying to keep my minutes to 5 minutes, so I'm going to do a quick analogy. We take it for granted that the local government can tell us that over here you can build a single family home and over there you can build an apartment complex and things like that. Over here you can build this, over here you can build that, and we just take it. We're talking about constitutional private property rights. Imagine if you were to move into a community and the local government were to tell you, well, the rules are over here, you can talk about politics, but not religion. Over there, you can talk about religion, but not politics. And hey, we're telling you when you move in, so you can't complain about your constitutional First Amendment rights being violated. As Americans, we'd be outraged. Same if it was the Second Amendment. Over here, you can own Glocks. Over here, you can own shotguns, but not vice versa. We would say that's outrageous. We say that violates our First Amendment, our Second Amendment rights. Well, then why don't we say the same with our Fifth Amendment private property rights? That's the root of the problem. Local control. Local control should be, I control my own property. That's the localist form of local control. Courts have largely avoided land use controversies, preferring to leave property owners to the mercy of city councils. The housing issue, though, is a bipartisan lane through which state legislators like yourselves can drive a property rights agenda that increases the supply of housing by lowering the amount of regulation. As an aside, and I know I'm nearing my 5 minutes, I want to commend and congratulate the Tennessee legislators and your predecessors who understood that centralized command and control is bad when it comes to land use. Back in 1981, your fellow legislators made rent control illegal. I wish the Supreme Court of the United States had that same wisdom that the Tennessee legislature did back in 81. The problem with rent control. A landowner should be able to charge what they want. And when the market is allowed to operate freely, prices come down. And then just a little less than a decade ago, you made inclusionary zoning illegal. That's the idea that forcing builders to build homes below cost in order to build some free market housing will somehow increase the supply of affordable housing. No, it doesn't. The loss of income has to be recaptured elsewhere, or the builders just won't build because they can't make any money on the project. It won't pencil out. So they either upcharge for the other free, quote unquote, free market housing that has now been regulated to be extra in cost, or they just don't build at all, which takes away from our supply of housing. Either way, we get less housing produced. And so again, I want to commend Tennessee for recognizing almost a decade ago that that should be illegal. With that, I know I've got now 6 minutes. I'm going to wrap up. Say I want to commend the idea that you'll be bringing more bills in the housing space. I also have had some preliminary discussions with Governor Lee's office and understand they also intend to address housing. Less regulation equals more housing. It's a supply and demand problem. And so if we cut regulation, we will have a greater supply, and that will resolve our housing cost crisis. Thank you, Mr. Chair.
Thank you, Mr. Miller. And it's my understanding that when we have a larger housing supply, we have a lower cost. The free market does indeed work. We appreciate you being here, and for us to have someone here that is such a background in the national space and the national conversation about this. With regards to, you bragged on us, but where are areas that from an outside view looking in that we could do better in as far as a legislature from looking into improving our property rights legislation? What are areas that could be addressed that could serve to push down things? What I'm trying to do with some legislation later is mandate that utility companies allow third parties to install so that they're not subject to the scheduling of crews because time kills deals, time adds expense. And so trying to get things to where it's in the hands of the provider as much as possible without having disinterested third parties controlling project schedule. Are there other areas that you see that need addressing within the private property rights space within our state?
Yes, Mr. Chair. First of all, I would say yes. From a national perspective, the concept you intend to bring, the idea that we allow private inspectors to do what we normally would say government inspectors should do, works. Florida tried that just a few years ago, and that has sped up the process from permit application to permit approvals. And that's really one of the major problems with the building space and why housing gets so expensive are the delays. And so to the extent that we could empower private enterprise to fill in for government inspectors, that would be a positive step in the right direction. And then more generally, I would say other efforts to eliminate delays, shot clock bills. A shot clock bill is the idea that when you apply for a permit within a specific amount of time, whether we call it 60 days or 90 days, the government has to give you, the zoning board, whoever's making that decision on your permit application, they have to act. And if they don't act, by default, the permit is approved. By eliminating delays or by giving the builders and developers specific amounts of time that they know, okay, it's going to take me this much time, but then I'll have a decision, they can figure out what their costs are going to be. Projects, Pacific Legal Foundation, we represent property owners who sometimes their desire to build a simple home can take a decade or more because the government fights them. And that is just untenable. And it helps explain why we have such a housing cost crisis across the country. So I would say anything that the state can do to reduce the amount of delays and the fact that we don't know how long it's going to take. There need to be specific, as I said, shot clocks is what we call it, in place. And that will help increase the supply of housing because the developers and builders will have more stability and they'll know ahead of time, okay, this is what I'm looking at.
This could be a free-ranging conversation. That I find also that the subjectivity of those involved sometimes leaving that decisions to be made to subjective human. Different people have different thoughts, and sometimes things get mixed up along the way there. Just one more question from me, and then I recognize others. What'd you say your record in front of the Supreme Court was?
So Pacific Legal's record over 52 years is now 18-2. We've won 18 cases. I was part of 2 of those cases. We've lost 2. I should emphasize, we take a lot more cases. We try to take 20 a year to the Supreme Court. They agreed to hear 20 of our cases in our 50 or so years, and we're ramping up. I was part of the 10th win, and that was about a decade ago. And just over the last decade, we won 8, and that might 8 more. So 18-2.
That's pretty good. To my committee members, I saw an interesting vignette. It is actually Ronald Reagan on the Johnny Carson show. And he talked about the fact that whenever bureaucrats get involved in the process, that whenever they ding somebody on violations, it's the one time in America that you're assumed guilty until you have to prove your innocence, as opposed to being innocent until proven guilty. And that's something that I'd like for us to all consider. Dr. Martin? You're recognized.
Thank you, Mr. Chairman. Thank you for coming. A timely discussion here in Tennessee. One thing we run into, I'm in rural West Tennessee, so contractors and getting individuals even to build homes is an issue. So what's something you've seen across the country that you could recommend, maybe from our standpoint, to look into to help increase access to those or increase contractors in those rural communities?
Mr. Miller.
Mr. Chair, I think that's an excellent question. One state I would point to that is doing good stuff is Montana. Governor Gianforte, what they call the Montana Miracle, what he has done to help increase the supply of housing, which then inures to the benefit of contractors, is decide at the state level that any single-family resident zoned property has to allow for a granny flat or a Fonzie flat, or what we call an ADU. What you're doing there is you're saying that a single-family resident zone piece of property, so would normally under typical state and local rules would have 1 home, can now have 2 homes, 2 places to live. And so you're doubling the supply of housing. And by putting it in at the state level, and, again, I want to emphasize local control. To be sure, I'm not an expert on Tennessee's home rule rules, so I don't want to get too over my skis. But the state created the United States. The states created the United States. The people, of course, did. But the people, through the states, created the United States. The local governments are creatures of the state. So the idea that the state can establish ground rules for housing and for zoning, to me, should not scare anybody. That's really the way our system is supposed to work. So here in Montana, the governor said, and the state legislature said, any single family residence zone property, we're going to allow for duplexes or granny flats. And we are seeing slowly but surely that law is having some positive impacts on the ability of builders, developers, contractors to build. I'll give a specific story because we intervened in litigation about that law. Clancy Kank is a elderly man who has 2 brothers who were Vietnam veterans, and they need his personal attention. And so he wants to build adjacent to his property a duplex for his 2 brothers to live in so he can look after them. The government wants to help him, but interveners are trying to say, no, that's illegal because the neighbors don't like the idea of having a duplex in their neighborhood. But as I said, the state legislature recognized duplexes and granny flats. I call it a Fonzie flat. For those of you who are old enough to remember Happy Days, if you remember Johnny Carson, you'll remember Happy Days. Fonzie lived over the Cunningham's garage. No one thought that was unusual. When I grew up, no one thought it was unusual for there to be a duplex and have 2 families living in the home. But now we take the single family residence concept and make it a holy grail of living because we're afraid of change. But in fact, it's the change over the last 50 years in favor of single family residence zoning and some of the rules about size of the lots and the like that have created this housing cost crisis. I could go on, but that's hopefully addresses your question.
Yeah, absolutely. Thank you, sir.
Chairman Bricken.
Thank you, Mr. Chairman. I have a question dealing with low-income housing tax credits. We have certainly in the state some, I think, generous tax credits for low-income housing, and this year we're going to be participating in a federal low-income housing tax credit. I guess I'd like to get your comments. Do you think the statutes that provides these tax credits is crafted in such a way to really generate new housing stock for low-income citizens or not?
Mr. Miller.
Mr. Chair, without knowing the specifics of the program, I will say that generally Pacific Legal Foundation would argue that when we start giving tax credits, we are picking winners and losers. And we just want to get the government out of the business of picking winners and losers, even though it might be well intended. We've had more than 50 years of those sort of government engineered efforts to increase the supply of housing, and the results speak for themselves. It's not working. When we talk about affordable housing, the homeless crisis across the country has burgeoned over the last 50 years. We've always had homelessness, but it generally usually flowed with the economy. But that has changed over the last 50 years. And it's because the government eliminated like single room occupancy apartments and the things like that by zoning, took away what we used to call affordable housing. And now the government then tries to play these incentive games to manufacture a supply of housing. It just simply, the results speak for themselves. It has not worked. So generally, without knowing the specifics, we generally don't like that. We just want to see less regulation, let builders, let developers build the housing. So somehow developers have gotten a bad reputation over the last 50 years, and it's intriguing because it's over the last 50 years that our housing cost crisis has become so extreme. I should emphasize, this isn't a new problem. President Reagan in 1982 recognized it with a commission on housing, but the problem has just gotten worse and worse. By cutting regulation, as Mr. Chair has suggested he's trying to do, that's the way to increase the supply of affordable housing. More supply will bring down the cost.
Thank you, sir. And we'll wrap up here. I see folks that we don't normally see in our room, so they're probably wanting to take it over. But I have an answer to why developers have gotten a bad name in the last 50 years. It's very simple. Scooby-Doo. You ever notice when they pull the mask off the villain, it was always the evil developer that was trying to take the person's farm or their home. Always. So Scooby-Doo has changed people's perspectives over for an entire generation. But we're going to finish this conversation today. I find it very intriguing. But with Representative Hemmer, and hopefully you'll be around the building some later today, that if anybody sees you, they can pull you aside and engage with you. But Representative Hemmer, you had a question.
Yes, sir. Thank you. Just real quick, from at least our state's perspective, there's not a lot of support financially for affordable housing initiatives. Our THA, our housing entity, they're self-sufficient, only basically from their revenue comes from, federal flow-through grants and loan programs, et cetera. So what are some of the best practices other states are doing to support affordable housing, not just from a policy perspective, but actual dollars and programs?
Well, I don't know if I've turned this on or off.
No, you're on.
Okay. I think that question speaks to the concern. The government means well, but it throws money at problems. Throwing the money is not the way to solve it. The way to solve it is to stop taking money from one person and giving it to another and just start cutting the red tape. And it's those steps that will increase the supply of housing. It is not taking money from Peter to give to Paul with the idea that Paul will then build housing that will then flow down to be quote unquote affordable housing. I know the intention is good, but intentions don't speak to the results, and the results speak for themselves. We have less affordable housing, as Mr. Chair said, about the next generation. And I'll say firsthand as well, my children who are adults now cannot afford to live where they grew up. That was simply just unheard of when I was a kid. There would be parts of the town where there were starter homes. We've taken residential land use regulation, zoning, and made it impossible for our generation, not impossible, but near impossible for the next generation to live in the same communities, maybe where there are teachers or our police officers, or perhaps they work in our yards or in our homes. We've made it impossible. If you're good enough to clean my home, you should be good enough to be able to afford to live in the same community where I live. But we have made zoning and residential land use regulations so restrictive that we've prohibited that, and we have to roll that back. It took us 50 years or so to get here, So let's try and get it done faster to get back to where we used to be.
All right. Thank you very much. Mr. Miller, again, we're grateful that you're here. We appreciate you sharing your thoughts with us. I know that Chairman Lafferty had one final question for you, but it looks like we're up against a hard break, so he'll get with you afterwards. But thank you for being here. And so we are going to go back in session just in time to adjourn this meeting.